Hello, everyone. Welcome to yet another episode of Vidhi's Book Adda series, where we discuss important books, themes, and ideas relating to Indian polity and the Indian economy. The book that we've chosen for today's discussion is The Antitrust Paradigm, authored an author who sits with us today with a very rich experience both in enforcement and in academia, Dr. Jonathan Baker. Thank you so much for allowing us to discuss your book today in our book Adda. So we will start this book Adda with an overview of the book by Dr. Baker, Jonathan, if I may. And we will then proceed to a moderated panel discussion where we will talk about some of the prominent themes emanating from this book, specifically in the context of how can we use antitrust as a buffering tool to promote fair bargaining for gig economy workers. And for this, I am joined by three other panelists. We have with us Dr. Amber Darr. Amber, it's always a pleasure to have you, with us. And she is a lecturer in competition law, currently teaching at the University of Manchester. She's also a senior research fellow at the Vidhi Centre for Law, Economics and Society. We also have Mr. Ujjwal Kumar, who is an associate director at CUTS. And CUTS needs no introduction. CUTS has been doing some cutting-edge work in the field of competition law and policy well before the Competition Act was enacted, in fact. So that's saying something about CUTS. Finally, we have Miss Vellah Kigwiru, who is a doctoral fellow in the Technical University of Munich. She is also an expert that has contributed to GIZ's course on competition law and gig economy. I will paste the link of the course shortly, and I would really urge our audience to check the course out. So over to Jonathan. I would love to hear about some of the themes of the book, and then we will get into a discussion.
Thank you very much for the generous introduction, and I'm delighted to join you at an unusual time. It's actually early in the day for me and late in the day for all of you. You've got an interesting topic, the role of competition law in promoting fair bargaining for gig workers. It's timely and interesting. And I'm delighted that you're interested in my book, which I wrote 5 years ago. So let me begin by explaining why I wrote the Antitrust Paradigm. Over the most of my career, which was well before that, U.S. antitrust law seemed to be in a reasonable place. I started working on the book around 2015, but by then I was no longer complacent. I'd become worried about growing market power, and I saw accumulating economic evidence, much of it since 2010, showing that market power had been growing for decades in the United States. That I won't go through the evidence, but it included, for example, increasing markups and declining economic dynamism. And I became concerned that antitrust law was not working. U.S. antitrust rules had been relaxed substantially around the 1980s. And that relaxation had gone too far toward trying to avoid chilling pro-competitive conduct. And as a result, the U.S. antitrust laws and antitrust enforcement were not sufficiently deterring the exercise of market power. And so my book describes the problem, and it suggests ways that U.S. antitrust rules should be reformed. And so let me just turn now to just a piece of what I did and talk about online platforms and sketch briefly some of some competition issues they raise that I talk about in my book. And I'll begin with what's probably very familiar background, but just to make sure we're all in the same place. So online platforms facilitate economic interactions and facilitate competition among end users. So for example, a shopping platform facilitates interactions among shoppers and manufacturers. But it also facilitates competition among manufacturers on the platform. Or a search engine is a platform that facilitates interaction among advertisers and consumers, and the advertisers compete on the platform. And there are many other examples of online platforms. That's just to make sure we're thinking about the same thing. And some platforms aren't just the platform, they're also users of their own platform. So Amazon sells private label products on its marketplace. And Google has a search engine, which is the platform, but it also provides shopping services. And it's not surprising to see in this world some online platforms become dominant in their area, because these markets often tend towards a dominant firm. That's because of network effects and scale economies in supply. But dominance is not inevitable, because user switching costs might be low, or users could vary in their preferences for platform features. So for example, where I live, there's no dominant restaurant reservation system. And that's probably, these are some of the reasons that it's why. Now, a lot of the competitive concern involving dominant online platforms involves conduct that excludes potential rivals and fringe competitors, excludes other platforms, or potential platforms, or entering platforms, or smaller platforms. And a dominant platform can obtain market power or protect it from erosion by making it hard for those kind of rivals to take business away from it, which is what the rivals need to do to get network effects or scale economies, which they need to compete themselves more effectively. And you can also have competitive problems on the platform, where a platform, for example, one that's also a platform user, can obtain or protect obtain or protect market power on one of its sides by excluding end users that compete with it on that side. So that's just the general framework. And just to and there's a host of types of exclusionary conduct that platforms can use that to obtain or protect market power, either as platforms or on a side, that I guess I won't go into. I'm a little worried about how much time there is. I want to make sure we get to the conversation that you all want to have. So with that background, let me say something about one particular policy issue that I talk about in my book that may come up in antitrust cases that implicate the gig economy issues that are the subject of today's program. And just to make it concrete, I want to talk about a hypothetical antitrust case, and purely hypothetical, involving Uber, a ride-sharing platform. But I'm making up all the story. It's not about Uber really, okay, in any particular country. So we'll think of Uber as a ride-sharing platform that has two kinds of end users, drivers and riders. And just suppose hypothetically that Uber engages in some kind of conduct, and I won't even bother to explain what it might be, that makes it harder for the drivers to also drive on other platforms. They can't drive on other ride-sharing platforms as easily. They can't multi-home, is the more technical term, or not do so easily. And suppose that the result is that the other ride-sharing platforms have a hard time getting drivers.
Yeah.
And then that gives Uber market power with respect to drivers.
Yeah.
It can also potentially give Uber market power with respect to riders, because Uber would have all the drivers, and but I just want to ignore that because I want the antitrust issue. The policy issue I want to talk about gets complicated if I start bringing that into the story. So we're worrying about market power with respect to drivers. And I want to suppose that Uber uses its market power to pay the drivers less per ride than they would have otherwise gotten. Now, if that's the only effect of Uber's conduct, that would presumably the conduct that that would protect its market power or give it market power and let it lower the price paid to drivers would presumably violate the antitrust laws in the United States, and I would guess elsewhere too.
Yeah.
And it's well established that in the United States, at any rate, that a reduction in competition violates antitrust laws, regardless of whether the victims are downstream buyers or upstream suppliers, including workers.
Right.
And so it wouldn't matter, in my example, whether we think of the drivers as supplying rides to Uber or buying access, meaning suppliers, or as buyers buying access to riders from Uber. Just end users that you can reach the end users, harm to the end users on the platform, regardless of how you think of them. And now, in my hypothetical example, Uber's conduct also has another effect on the other side of the platform. So when Uber pays its drivers less per ride, it passes through some of those lower costs to riders. And that reduces the price of rides. And remember, I'm ignoring the possibility that Uber also has market power on the rider side of the market. So the price of rides is getting lower.
Yeah.
So in other words, the same conduct harms the drivers, who are the end users on one side of Uber's platform, and then it benefits riders, who are the end users on the other side of the platform. And Uber might want to say, if you challenge this conduct as a competition problem, Uber might want to say that, well, if the benefit to the riders is large enough, that would outweigh the harm to the drivers, and that would justify the conduct that's pro-competitive overall.
Yes.
And that kind of argument, for trading off harms on one side of a platform against benefits on the other side of the platform, is likely to come up often when you think about competition issues involving platforms.
Yeah.
And in general, that argument is not allowed in the United States if the sides of the platform are viewed as different markets. If you say each side's a market, the U.S. courts don't let efficiencies in one market offset harm to competition in another market. But there's some qualifications to that. The antitrust enforcement agencies sometimes do that in deciding what cases to bring. It's a matter of prosecutorial discretion, like particularly whether to challenge a merger. And this policy question is debated, and because there are arguments on both sides. So there are two arguments against allowing these kind of cross-market trade-offs. And I'll explain them in terms of my hypothetical example. The first one is, if we're going to look at the benefits or harms that go beyond drivers, the ones who are injured, that we're thinking about protecting with an antitrust case, why stop with the riders? So the drivers are earning less, so fewer people want to drive for ride-sharing platforms. That might mean, I'm just making it up, that the better drivers change jobs and they switch to driving for package delivery services, or taxi companies or something like that. They leave Uber with lower quality drivers, and that reduces the quality of rides. The rides start taking longer, or the rate of accidents goes up, something like that. And I can make up other stories where there's harm elsewhere. The companies that rent cars, maybe there are companies that rent cars to drivers. Now there are fewer drivers and they're harmed. And the point is that once we go beyond the market where the harm is, in this case, the drivers, the market for driving on Uber. Once we go beyond that, it might be impractical or impossible to work out all the benefits and harms of the conduct throughout the economy. So why just look at the one that Uber wants to look at when there are all these other ones too that we can't have, even that are potentially important but have a hard time to measure. So that's one reason to not go beyond looking at the drivers. And the other reason is to just look at the harm to the drivers, not allow cross-market trade-offs, is essentially to protect the political support for antitrust. In other words, it's hard to tell a driver, the antitrust, yeah, you're being injured. You're getting paid less than for driving than you would be without this market power and exercise of market power. But we can't do anything about it under the antitrust laws because you have to earn less because the conduct benefits riders. That's a hard thing to tell the drivers. It's okay. Now, there's an argument on the other side for allowing these cross-market trade-offs, and that it's a serious one. And it's that we don't want antitrust laws to seem protectionist and stand in the way of efficiency and growth. So let's suppose the conduct hurts the drivers, but only hurts them a little, and it helps the riders a great deal. Isn't it a good thing overall to allow it? That would be the argument the other way. And there is a sense in which U.S. antitrust law sometimes does allow harms on one side of a platform to be offset by gains on the other side. And it does that for transaction platforms like payment systems by defining a market. Instead of having one market for each side, it has a single market that encompasses both sides, two-sided market. And that's a recent development. It might be construed narrowly. It may not be that big a deal. We don't, it's a little hard to know yet, really. Now, in my book, I argued largely in favor of prohibiting the cross-market welfare trade-offs, essentially just looking at the drivers, outside of occasional situations where the competitive benefits in one market are really disproportionate to the harms in another market. And I was worried about the efficiency law, the growth and efficiency. Right. And I also came out against the two-sided market workaround. I don't like that at all. I think for a bunch of reasons that I don't want to get into now. But this question is not entirely settled in the United States, and it'll likely come up in other jurisdictions, like India, I would guess, whenever competition harms end users on one side of a platform, and benefits end users on another side. Now, I know much of the gig economy operates on online platforms, so I hope this little taste of my book will help frame the rest of today's conversation. There's really a whole lot more in the book than this, but I think I thought this would be an issue worth highlighting because of the policy problems you folks are concerned. So I'll stop right there. Thank you.
Thank you so much, Jonathan. That was actually a very comprehensive overview of the book, and I have many questions to follow up. So, we will follow this with a discussion on some of the themes of the book itself, and we will have each question focused to panelists. And, if anybody has opinions apart from the panelists that it's directed at, please feel free to raise your hand and chime in. All opinions are welcome. So, the first question, I think I'd like to focus this first to Jonathan because it's directly out of the book, and to Amber, to the both of you. Something that and to get this out of the way at the outset, because antitrust enforcement or competition enforcement is as much a political choice as it is an economic choice. Now, something that I want to understand, and because you argue for this quite passionately in your book, to start thinking about competition law not limited to not the competition policy, not limited to the narrow competition laws that we have, but to sort of make it a bedrock principle for how we think about regulation in digital economies itself. Now, I want to understand how that feeds into, aspirations of a country vis-a-vis other countries when it comes to digital economy. Specifically in India, because we are a tech-heavy economy, we do have a lot of startups and the like. So a stronger enforcement for antitrust or competition always comes with the fear of chilling innovation. But at the same time, India is also a country where there are staggering inequalities, especially when we look at gig economy workers vis-a-vis their bargaining capacity with some of these big tech platforms. So making a stronger case for antitrust enforcement, to protect vulnerable populations like this becomes another important goal that, the Indian law and policy ought to sort of pursue. But then this puts us in a spot where we have two competing goals that we're trying to chase, perhaps with the same tool. So how do we sort of square, these competing goals? And I just want to understand what the experience has been like in the US with something like this. And Amber, how do you see this playing out in India?
So shall I start, Amber? Is that all right? Okay. Let me. I actually want to question whether there's as much of a conflict as you're making up. And in particular, question the premise that more antitrust enforcement in India, say, would stifle innovation and harm the firms that are in India that are trying to compete globally.
Yeah.
We had a similar policy debate in the United States 40 years ago.
Right.
That was when U.S. firms began to face increasing global competition in some important domestic U.S. markets like automobiles and steel. There was a whole lot of interest in Japan, Japanese firms being successful at the time, and a big policy discussion, and it became an antitrust discussion in part. And the policy issue then was similar to yours, the one you just framed, which is whether greater international competitiveness would justify lessened domestic competition, whether somehow we should allow less competition domestically to get better firms be better global competitors. And that debate led to a lot of research, and in particular there were two big. So this is like history to me, and I bet you guys are also young, but you never heard of any of this. But there were two major studies that were looking at across all kinds of countries and all kinds of industries at the time by economists who were interested in business strategy. These are very well-known people, like and separate studies that each turned into a widely read book. One was by Michael Porter, who was a very famous business strategist, and the other was by the McKinsey Global Institute, which is affiliated with a consulting firm. These are, I don't know, one book was like 1990, and the other was like early 2000s. And so they were business strategy folks who were heavily involved with economics. And both studies found that domestic competition generated substantial productivity benefits in the country. And they found that vigorous domestic competition in an industry helps make the national industry gain a competitive advantage and keep it internationally. Yeah. And it also boosts productivity in the country as a whole. And it was even one of them, I think, was arguing that the effects of domestic competition on welfare were comparable to good macroeconomic policy. I mean, they were big, and these conclusions that were looking at different industries and countries at the time are consistent with more recent empirical economic studies. And those studies consistently find that enhanced competition leads to greater productivity in an industry, and the exercise of market power reduces productivity in that industry. And so my bottom line is that there's much less of a trade-off than the question you posed supposes. And I would think that on average, there may not be any trade-off at all. That you can have the best of both worlds with more competition.
Oh.
So, Amber, you want to add anything?
Yes. Let me just begin actually just by thanking Vidhi for inviting me, and Manjushree and Radha particularly. I think we've had a little bit of difficulty in coordinating because I'm not where I usually am. So thank you for bearing with me. And I also really wanted to say, Jonathan, that I enjoyed the book as much as I was able to read it. And I was thinking to myself, how prescient. I mean, he was forecasting the future in many ways in 2019, because I think there is now a greater interest in market power, and we are, the FTC particularly is taking a greater interest in market power. Maybe not to the extent that you would have hoped, but I think there is a shift which you you anticipated as unlikely, but it is nevertheless there. So to respond to this part of the discussion, I wanted to actually focus on three broad themes that you bring up, Jonathan, in your book. First, that something that Manjushree has also said, that antitrust, as we see it practiced, is really a political bargain, which is struck between the right and the left, but also between the hypothetical conglomerate of suppliers and consumers, because they don't really come together, but their representatives do. The other theme that I found really interesting in the book, which is woven throughout it, is that many of the issues that relate to big tech, and this is something you just said again, we've experienced already in the traditional economy. So it's not as if we're walking into the big tech sphere without any understanding of the legal issues that might arise, and we can benefit from actually looking back at the traditional sectors and understanding the kind of problems that market power or anti-competitive practices have raised. And finally, the theme that is woven throughout, I think, is that antitrust can change and evolve, provided there is a broad-based effort that includes enforcement institutions and courts and competition authorities and advocates and public, but really it is possible to allow it to evolve. So for the purposes of my comments, I would like to locate myself in India very particularly, but I think many of the things that I'm saying are also relevant to the global South as a whole, particularly those who are sort of in, making inroads into the digital sphere. So this location, I believe, is important, has important implications of how we view antitrust or competition, and also where we strike the political balance, which, again, Jonathan, to draw upon your work, is really the cornerstone or the starting point of an effective competition policy. So my first observation is that India, the first implication rather for India is that, its competition rules, especially the 2002 Act. I know we've had a revision in 2023, and we're also looking to a new digital act, but it's the core sort of competition principles are not organic to India. They've been adopted from elsewhere. They sort of represent a different balance that has been struck in a different space. And I think that is important. For instance, the EU and UK enforcement agencies, the US enforcement agencies in particular, rely on economic principles that reflect their reality, reflect their objectives, their economic priorities. India has tried to do some of that, but it's more at the sort of periphery, but not in the competition principle. So that's one basic principle that we want to bear in mind. The second thing that is different with the Indian experience, probably I would say the global South experience, is that the institutional landscape in which the competition law is sort of inserted, for lack of a better word, is very different from the institutional landscape in which the antitrust, the US antitrust emerged, or even the EU and UK emerged. So for instance, when I read about the evolution of antitrust in the US, I'm sort of struck by the fact that strong distributional and just judicial institutions allowed antitrust to sort of have that very neat economic core, which has not always been neat. I understand that, but I think gradually, really sort of go towards that really sort of technical economic formulation, which India has a different history. India has a very strong sort of social welfare ethos, which is borne out in its constitutions. It doesn't have the same, the same level of, I would say, I shouldn't say level, but I think the word I'm trying to look for is that the judicial institutions and the distributional institutions work to a different ethos, perhaps, and that's something to be borne in mind when we think about a solution. And the third implication that I want to consider is that the institutional design of the Indian competition system is very different specifically from that in the US. I think there's a lot more commonality between the EU and the UK, but certainly very little with the US, which for our purposes means that the courts don't get involved except in a very limited way. So the courts, if they're coming through the appellate trajectory, the courts get involved in sort of the general principles of law. If they're sitting in their appellate jurisdictions, there is other intervention as well on constitutional points, but again, they're not touching upon the the core competition principles, which are really left to the competition authority, which is the judge, jury, and executioner formulation, the monistic enforcer. And to some extent, I think the appellate tribunal, which is now no longer a specialist competition tribunal, but a corporate law tribunal, that gets involved. And I'm curious, I mean, I haven't done enough research on it to make a comment, but I'm curious to understand whether they really rule on competition issues or not. So with these thoughts, I want to sort of just quickly talk about how India may regulate big tech in this context, and what can it do to do it in a way that doesn't dampen innovation and economic growth, which is, of course, a key concern for the Indian economy, but also does not disproportionately harm the newly sort of emerging category of the gig worker. So the first idea that comes to mind is, again, in fact, again, something that I draw from your work, Jonathan, but also elsewhere, and it's something very, I think, dear to my heart, is refocusing the antitrust enforcement on the issue of market power as well. I think that's something that we don't see in the US, but it's beginning to come back. I mean, the big case against Google, so we'll see what happens. But I think there is, there is some hope that something will happen. And this idea that focus on market power actually leads me directly then to the EU Digital Markets Act and the proposed UK Digital Markets and Consumer, I forget the full name, the DMCC Act, both of which are focused on gatekeepers, which suggests to focus on, market power and really concentrating enforcement action on not people, but platforms or entities with greater market power. I think if India adopts a strategy like that, that will allow innovation to actually, it will spur innovation, I would say, but it will allow innovation to grow at that, the smaller platform level and really sort of go after the big platforms for the most egregious economic harms. I think the challenge will be balancing regulation with the need to attract and retain foreign investment, which again is a big concern for India. And for instance, in the traditional sector, there was a competition case against Monsanto, which dragged on for years. Eventually, the court's decided that actually it's better to go to a patent court than to the competition authorities. They didn't want competition to get involved. There was a PepsiCo case, which was settled out of court because the farmers basically had a sit-in. Again, we did not see the court's ruling on superior bargaining power or abuse of dominance. I mean, those cases never saw the light of day. More recently, of course, the competition authorities have gone after for instance, the Google shopping case. They've gone after, they've taken a stance on Google. They've taken a stance on Amazon Flipkart in the Amazon Flipkart case, which shows some willingness for the Indian regulator to regulate big tech. But I think the idea is that the focus should be on the big players and allow the smaller players to continue as they will, to continue to innovate and develop better products. My slight concern is that that this should not turn into a nationalistic, protectionist exercise on the part of India. There is always that danger, and if we, in Amazon, Flipkart, if we see the balance tilting towards Flipkart, it really makes you wonder if this is objective standards that have been applied, or is this more of a protectionist ideology? But I don't have enough information to make a statement on that. But that I think will be important. And I think the other thing that will be important for India to consider is how they define gatekeepers, or what is the benchmark for their gatekeepers. And it needs to be, again, a carefully crafted balance, which doesn't just focus on financial or value thresholds, because that might bring too many players in the net. But maybe include some social indicators at that stage for the definition of gatekeepers. But again, the challenge would be to make sure that these are objective indicators and we are not going towards it sort of a disguised protectionism. Why I think that's a bigger concern for India, because we have a history of protectionism in India. And I think that kind of ethos may continue to inform future work itself. So, but what will India do to manage its relationship with gig workers? I think that the labor rights aspect of this question, I'll pick them up later in the discussion. But at this point, I just want to say that India can, in fact, benefit from Jonathan's argument that market power exercised against small suppliers. In this case, the gig workers will be the suppliers of their services. And if they result in reduced wages for these gig workers, that is potentially an anti-competitive concern that may be taken up by the Indian Competition Authority, the CCI. Again, I think this would require some proactive thinking on the part of the Competition Authority. We'll talk a little bit later about whether the Competition Act actually gives them space to do that. I don't really see the gig workers themselves having the capacity to raise such claims. Again, something very different from the US, where I think we have a much more informed populace. So I think we are looking at a little bit more interventionist role for the Competition Authority in India, and perhaps a more nuanced role, at least in terms of defining what market power looks like in the Indian context.
Absolutely. Thanks so much for that, Amber. And in fact, sort of taking cues from what Amber and Jonathan have spoken about, in terms of two prominent themes that came out here. One that, as Jonathan said, in ensuring that innovation flourishes and that several parts of the population that interact with big tech are doing it in a fair manner, don't have to necessarily be competing goals. They can sort of go hand in hand. But a huge assumption that it sort of presupposes is the fact that competition law can be expanded meaningfully, and the state capacity in India, in fact, allows for it. And the state capacity specifically being the way the Competition Commission of India is structured sort of allows for it. And this is where I would really love for Ujjwal and Vellah to come in terms of how do we see, if at all, keeping in mind the current capacity constraints that India has when we look at the Competition Commission of India, strategically should gig economy worker rights be something that the Competition Commission of India should, concern itself with? I'm not here on normative question in terms of whether it is the right thing to do, but a question on is it realistically possible for them to do in a manner where the intervention proves to be more efficient than how the market was prior to such intervention. So that's part one. And second, Vellah, I would really love to hear from you and the course that our collaborators GIZ has developed in terms of how competition law is carrying out similar objectives in other jurisdictions. So I would love to hear, particularly on the experience with other developing countries in terms of ones that face similar state capacity constraints in terms of how they are adapting their competition law and policy to deal with gig economy workers. Over to you, Ujjwal.
Okay, thank you so much. Thank you so much, Manju, for this opportunity. And also thank you so much, Professor Becker and Amber, for giving us the background in understanding really what is happening in the digital labor platform. Because ordinarily, we all know that competition law seeks to protect consumer interest. But the way the markets are changing, and from what Jonathan has written in his book, the harms in competition law are not just limited to consumers, the suppliers, workers, and other actors also are harmed by anti-competitive conduct. So you'll allow me to share my screen, but then also Manju, kindly share the link to the GIZ online course. And also the survey link, so that if you've learned something from what I'm going to present, would like to also hear from you.
Sure, the course is online, the course is on the chat.
So because we've already had a background, and Manju has asked me a question whether gig workers should have a right to collective bargaining. Collective agreements, fundamental right for all workers that allows them to bargain for better working conditions, like better salaries, social security, health insurance, and so on. But unfortunately, when you look at gig workers, collective agreements between platform workers are very rare. The reason is because they have been categorized as unemployed people, and unemployed people do not benefit from employment law, and neither do they benefit from competition law, because under competition law, they allow employees and employers to enter into collective bargaining agreements, but self-employed people are not allowed because they're considered to be undertakings. So despite this, we observe, all of us have observed in our countries, we've seen food delivery platform workers, Uber drivers engaging in public protest. Then the question is, if they're engaging in public protest, what are the sources of this public protest in this specific? I'll just go first because I have less than 10 minutes to present, to make my presentation. So because of the challenges that platform workers are facing, and some of the reasons why we need to really look at this issue of platform workers or gig workers is because most of the individuals that work on platforms are either people of color, and when you live in developed countries, you'll find that most of them are immigrants that are coming mainly from the global south. So that relationship in itself already makes them vulnerable, and therefore they need protection. So we came up with this course with GZ to look at what will be the potential and the limits of competition law in enhancing platform workers' rights to collective bargaining. So we've already shared the link, and you can also write to me at vellakidog@gmail if you want to have a deeper understanding of what we are really talking about. And this is some of the benefits that you'll receive if you do this course. And the most important, apart from gaining deep knowledge on this specific topic, because these are the things we relate with. We take taxes in and there. We have relatives who work with food delivery platforms, and they work with the e-commerce platforms as well. You'll also be able to earn a badge and certificate. And if you're a lecturer, you can also share this with your students so that they're able to also earn badges and certificates if they undertake this course. So one of the limitations of competition law, as I have argued earlier, is that it doesn't extend the labor exemption to gig workers because they have been categorized as self-employed people. And the other limitation is that in most cases, when issues of anti-competitive conduct have arose in the digital labor platform market, most of the competition agencies have subjected the platform's conduct to the rule of reason. The rule of reason simply means that they look at the pro-competitive gains from this particular conduct. For instance, when you look at predatory pricing, which Uber has been accused of, you find that most competition agencies have indicated that because of the lower prices that Uber has been charging, the consumers benefit from these lower prices. So that is the second limitation of competition law. So the potential of competition law, as many scholars and many competition agencies around the world are looking into, is to see whether we can extend the labor exemptions to digital labor platform workers. And this is the main question we are trying to answer in the GIZ course. So we came up with 4 justifications of why we really need to extend the labor exemption to platform workers in order to give them an opportunity to collectively bargain for better working conditions. And one of them is the issue of misclassification. So we have a number of judicial decisions from the EU Court of Justice. We have a number of decisions from competition agencies that have found out when you look at platform workers, you find that most of them do not really fall within the characterization of who is an independent contractor. For example, as when I'm in Nairobi and interact with the riding app drivers, you find that most of them work exclusively for the riding app platforms. They don't have another employer. So this is not like a flexible kind of job they engage in. So you find that they're also economically dependent on that platform. That is where they get the salaries and so on. And you also find that some of them do not even own the cars. Someone else owns the cars and then they employ the driver. So the question of flexibility in some cases do not arise. But when maybe you go to countries like the US, you'll find that some people, they have a full-time job, and then in the evening, they decide to go to the Uber app, carry somebody, and just go home. So for them, it's like a gig for them. So these are some of the things that we need to look at when we're looking at the question of whether to extend. And as Jonathan has said, these markets are highly concentrated. Most of these platforms have market power. And as Amber has noted, we really need to focus on the issue of market power, especially how do these platforms gain market power that makes it impossible for other platforms to enter into market. For instance, in the Kenyan market, we don't just have Uber and Bolt, we have more than 15 riding app platforms. But because of the network effects, because consumers already were used to Uber and Bolt because of the first mover advantage, they prefer using these apps, or because Uber provides security to these consumers, or also the question of who uses this app. It's the middle class or the rich people in society. So they will prefer Uber more than they will prefer Farasi or will prefer Little Cab. Because of this market power that they have gained, it becomes so important for drivers to even use the other app. And this is what makes them more vulnerable. And that is why we need to protect them, because at the end of the day, the philosophical foundation of having the labor exemption under competition law was to protect the vulnerable employee. So that is another one. The third one that we've identified in our GIZ course is that, and Jonathan has mentioned this, is that these digital labor platforms, in addition to enjoying the market power, they're engaging in exclusionary and exploitative conduct. In addition to predatory pricing, we have the issue of some platforms, especially in the food delivery market, whereby they ask drivers only to work for those specific platforms. So it's very difficult for the drivers or whatever to work, but in most instances, drivers, when you talk to them, they have a number of platforms they choose from. So there's a report that GIZ has, where they looked at the Rwanda's digital market structures, and this is some of the issues that some of the riders in Rwanda were raising. So that is another issue. So the fourth justification that we are looking at is that there's a lot of public protest, and there's no way we can just sit and say, we are not going to look at this market, yet we can observe public protest. So the question is, if these drivers are vulnerable, then what can competition law do? So these are some of the issues, and you can find one of the arguments is that because of the economic dependency that these drivers face, there's need to really protect and extend the labor exemption under competition law to the drivers. So I'll just mention what some of these competition agencies have done across the globe. So we have Ireland. Ireland in 2017, they amended their Competition Act, and they introduced two categories of self-employed people, the relevant self-employed people and the false self-employed workers, and those ones that are fully dependent self-employed people. So for the false self-employed person, according to the Ireland Legislative Act, as I had indicated earlier in the other slide, are those workers, when you look at the interaction with this digital platform, you find that they follow instructions, therefore they're controlled by this digital labor platform. They don't enjoy any independence, they're subordinated. And even when you look at them, you cannot really make a big difference between an employee and a self-employed people in this scenario. And then a fully dependent self-employed person. And some scholars have argued that the reason why we really need to protect these workers is the question of economic dependency. So for them is, if a self-employed person gains more than, their main source of income only comes from more than two persons or two sources, then they have become fully dependent self-employed people. And then, of course, we have the relevant self-employed people, which, if you look at how they interact with these platforms, they're simply self-employed people. The EU has also come up with guidelines, and for the EU, they have really indicated that there's need to extend the labor exemption, but this labor exemption will only be extended when the objective of the collective bargaining agreement is to improve the working conditions of platform workers. So they also look at the issue of economically dependent, that is if they accrue more than 50% from the platform. those that are in a comparable situation, just like what Ireland has done. They have made it explicit that digital labor platforms fall under this exemption. And also we'll observe, we have so many jurisdictions that are reclassifying people that were classified as self-employed people as workers. So these are the people that are included. And finally, I'll give you an example of the implication of whether we should extend the labor exemptions to our platform workers for them to have a right to collective bargaining. So this is a case from the Danish National Competition Authority, whereby an online platform called Health, which provides domestic workers or cleaners to households. They had two categories of workers. So they had the super helper workers, and then they had the ones that are also flexible. So for the super helper, they have a contract with the platform, but for the others, they didn't have a platform. But helper entered into a collective agreement with the Danish trade union to negotiate the salaries they were paying the workers, all the workers. But then the National Competition Authority was like, no. For the other category of workers, they were self-employed people. So they could not benefit from the collective bargaining agreement that Helfer had entered into. So one of the reasons they looked into, because competition authorities are going to look into the relationship to really define, is because they were bearing, just a minute, because Helfer did not bear any financial risk when it came to the other categories of workers. So what Helfer did was that it changed the relationship and then made the other category of workers now to be fully employed by Helfer. But then this begs the question, how will competition authorities be able to extend the labor exemptions to digital platform workers? So that is exactly what we are looking at. And on behalf of GIZ, we are welcoming all of you to look at the course, to read the content, and also to participate in undertaking the course. But then from a Global South perspective, all I try to push for when it comes to gig workers is the realization that these workers are economically dependent on these platforms. And even when there's existence of other platforms, that they're not able to really go to the specific platform because of consumer preference. Most of the consumers being on one platform. So it's like they're locked within this kind of ecosystem. Thank you.
You are muted, Manju.
I'm so sorry. Sorry, I would hear again. I think thank you so much, Vellah, for that beautiful summary of what GIZ's course looks like. I would really urge our participants, especially those that are currently studying or in the process of teaching, to sort of use the wonderful course curated by GIZ on economy, workers, and competition. But sort of squaring this discussion back to how to make this work in India. And Ujjwal, if we can start with some, the state capacity constraints that we're talking about, and Amber, I will follow that up with, how should we think of competition to begin with, given that we are on the precipice of thinking about new regulatory regimes for digital markets. So should competition, be, unfortunately, I think we've envisaged competition to be a horizontal, but I don't think that's happened in India given the timing at which the Competition Act was introduced. So we've unfortunately cornered competition into a small portion of the pie that is, that the CCI sort of had control on, where other market regulators that are a lot more matured and influential sort of don't allow a more expansionist role for the CCI to, intervene. So given these state capacity constraints and regulatory constraints that we have, how do we, see this issue of economy workers being addressed? Because I think we're all in agreement that platforms have a bargaining power vis-a-vis everyone that they operate with, in terms of sort of strong arming contracts or bargains in their favor. But in terms of a design question in that, how do we go about solving this? I would really love both of your inputs on that, and also to follow up perhaps finally from Jonathan in terms of how the experience there contrasts with what's happening in the US. Over to you, Ujjwal.
Thank you, Manjushree. And thanks to Vidhi and GIZ for inviting me for this impressive panel. Yeah. It's an honor to be with such a great exponents of competition law. Yes, I'd like to speak from the solution point of view. And in my opinion, competition law enforcement has a limited role to play as far as solution is concerned in safeguarding rights of the gig workers.
Yeah.
Because in India, the supply of gig workers is exponentially high than the demand created by highly concentrated digital market.
Absolutely. Yeah.
So I think this is the source of problem.
Yeah.
And the solution to the problem of this market concentration, particularly the highly concentrated digital market, platform market, can be achieved not much by competition enforcement, but mainly by the whole of government policy approach,
yeah.
Which include data policy, our own national digital strategy, even industrial policy, investment policy. So we have to look at the larger picture rather than focus on competition enforcement much. And that is why we at GERTS have been advocating for adoption of national competition policy since long.
Yeah.
And so that all national and subnational government departments and agencies bear a competition lens in formulating policies and regulations.
Yeah.
And such as removal of entry barriers, availability of capital is one of the kind of thing, and proper guardrails for public safeguards, as well as technological solutions like digital public infrastructure,
yeah.
Like we have seen in Amma Auto, promoted by the Karnataka government.
Yes.
In Bangalore, they do not cut commission from the drivers, so their income is more. Such kind of promotion of digital public infrastructure will also be part of solution. Generally, our tendency is to look at competition authority for checking or reversing the phenomenon of increasing concentration in the market. But we understand that their focus is not dominance or market power or market concentration per se, but their focus is abuse of dominance or market power. Their focus is more on abuse, and so mere having 2 or 3 players in a platform market does not by itself trigger their action. Yeah. And in addition, to prove a firm is a dominant firm is also difficult when market share approach is taken. Generally, traditionally, it has been taken. That is why it is better to advocate for ex-ante competition policy solutions and rely more on this approach than competition enforcement. However, proactive use of advocacy function by competition authorities will be very important in this regard. And but having said that, I think that there are some ways where competition law and its enforcement can help us in India in this regard. Fortunately, I think the Indian law has some broad provisions, and hence many terms can be interpreted in such a way that can be gig workers' interest. First, in my opinion, is that there is a need to develop more jurisprudence and understanding on buyer's power. Buyer's power. This is, I think, the most important from the problems of gig workers. I think the Competition Commission in India has not much dealt with such type of cases, and if we go by the definition of the consumers in the Competition Act, the digital platform will largely be consumers and of the services that gig workers are selling, particularly thinking of the delivery boys, if you can think of. So delivery boys are the sellers while the consumers are the platform. Similarly, in similar conditions is there in the agriculture market, where farmers are sellers and traders who buys farmers' produce are the consumers as per the Competition Act. Just to deal with this apathy of sellers, like squeezed market price or squeezed payments in a monopsony or oligopsony market, instead of tilting towards consumer welfare, we need to tilt towards sellers' welfare. And we need that inverted thinking to be propagated. I think that inverted thinking is lacking at this point. Secondly, consumer welfare as standard is concerned, I think Indian law is flexible enough to accommodate broader interpretation. Whether or not we take it is also, I mean, as you suggest, that depends on the state, the regulator's capacity to kind of. But I think with the digital unit being set up, I think that capacity is likely to develop in future. And we see that the object clause of the Competition Act does say about keeping in view the economic development of the country. So when our interpretation or competition analysis take into account economic development of the country. Certainly that gives the leeway to competition authority, and particularly to move away from relying only on the efficiency approach alone. So, but I think the Commission of India has taken such approach in past. At least I'm aware of one merger review by Monsanto. It did take into account the ecosystem approach and allowed the merger only after putting certain non-traditional conditionalities, which was not seen earlier, like sharing of germplasm to public institutions for development of seeds, or allowing non-discriminatory access to potential business suppliers on any digital platform that the merging entity may have in future. So the judgment was very futuristic, and the dynamics of the market was taken into account rather than relying only on the static market. Thirdly, I would suggest that certain interpretations of existing tools in law and can be helpful. For instance, taking into account the factors like firms' control over data and firms' network effect while determining the market power or dominance. So not just for the market share. And our law does provide such inclusion, and at CLRC, the Competition Law Review Committee has flagged this, that it can be taken into account. Such interpretation will also discourage the tendency of big incumbent digital platforms using argument of new entrant in a market segment where they were not present before, the digital markets. So that will also be discouraged. Similarly, changing the way to determine the presence of entry barrier can be helpful to a certain extent. The barriers in attaining a critical mass of network effect should be the determining factor rather than mere creation of platform. Creation of platform is an easy task. Anyone can create a platform, but sustaining in the and having a critical mass of network effect is kind of a difficult task. So the entry barrier is really achieving the critical mass of network effects rather than just creating a platform. So this move away from this such kind of analysis will be useful for India. Similarly, determining relevant market narrowly, which CCI has been kind of doing of late, will increase the probability of firm being a dominant firm, and also bestowing more importance on the vertical integration in digital markets, which in traditional market were not taken seriously. I think this is also the time that vertical integration needs to be taken very seriously. And fourthly, and lastly, I would like to also flag certain tools that are missing in Indian law and which can be useful for the welfare of gig workers. For instance, concept of collective abuse of dominance. This concept is there in new law, but I think the jurisprudence there is quite weak. And the academic has to work on developing that. Similarly, a concept there is in the Japanese law called abuse of superior bargaining power. But again, that has been used very, very little, and the jurisprudence is quite big. So these two concepts, if we propagate first in the academic and then further suggest its application, I think that is good enough. So to conclude, I would suggest that it's better to rely. I would like to advocate both relying on more on whole of government ex-ante competition policy approach for gig workers' welfare than on competition reform. But competition enforcement with certain changes in competition analysis and interpretation can also be helpful. And but I would also like to kind of propose these two concepts to be further explored. So I'll stop here.
Thank you, Ujjwal. So I think that also squares in with the reason that we were talking about an ex-ante intervention in terms of recognizing gatekeeper platforms, because the current philosophy in India underpins one where if there is a relevant market, you can only go behind the one that is dominant. But I think the philosophy that underpins, gatekeepers, the way EU is doing it and the DMCC is doing it, is that we're recognizing that in a situation of concentration, we may have to simultaneously go behind multiple players. And I think that is the sort of shift that I'm hoping that we will see in Indian competition law and policy as well. And Amber, sort of coming back to you on, how what is this renewed role for the Competition Commission of India is going to look like in the future, given that gig economy is just simply one other aspect in the broader digital economy that's now coming to the fore, and there will be similar pockets of areas that we will have to fumble a little before we decide on how to go about with enforcement. Now, this question often requires us to consider two things. One, of course, the state capacity of the CCI, and second, the turf that the CCI can operate on, because currently gig economy workers' rights, very interestingly, is a part of labor laws in India. Like the labor courts are debating on potential questions of how to protect gig economy workers, and also recently we've had the Rajasthan Gig Economy Workers Act, as recently as in 2023, that aims to promote fair bargaining for gig economy workers. So I think this sort of squares in with what Ujjwal sort of pointed out about it cannot be one instrument that we rely upon. But what's interesting to me is that given that we are seeing action in the domain of labor law, what else are we hoping that competition brings to the table, and what's the best way for it, for that to be designed?
Okay, thank you, Manjushree. I'm just going to share some brief thoughts. I think the best way is perhaps something that we will arrive at broader consultation, but just a few thoughts to get us started on this. And I would like to just focus more on competition, because really my knowledge of all the other initiatives is limited. I think I would like to just begin by saying that competition law is not really interested in labor rights. As a law itself, that's not where its focus is. So labor courts place labor at the center, and then look at at the world from the laborer's perspective rather, and they try to take more of a holistic view, a little bit like consumer legislation would look at consumer in a broader perspective. So would labor legislation. Competition is interested in, especially in the EU and UK context, which is the context I work in, they're interested in undertakings. So from that perspective, labor is inside the undertaking. It's an internal relationship. It's a little bit like the group company dynamic. Should we look into subsidiary agreements with the holding company or not? And we don't in the EU. That's a single economic entity argument. The EU law has, of course, Vellah referred to it, I think perhaps not by name, but she did talk about the exemption for collective bargaining agreements, and that's the Albany exception that we talk about. So, as long as workers are uniting for improving their own sort of welfare within the company itself, that's exempted from EU competition law. Now, the difficulty is that gig workers are not workers. They're not laborers, perhaps, in the general understanding of the competition law's understanding of labor law. Gig worker is not a laborer. Now, I know that's changing perhaps in India in certain places, but we'll come to that in a moment. So the gig worker is in fact could potentially be an undertaking, right? So I think that's a bit of an open question. What we can say is that there is possibility then to examine the relationship between between a competition authority and a gig worker, right? Within the existing framework as well. So within the existing framework of the competition law, you can look at, for instance, buyer cartels. If platform is buying the services of the gig worker, because the gig worker becomes the seller of services. I think Ujjwal talked about it with a lot of clarity. So I'm going to speak quickly, so just building up on his arguments. The gig worker becomes a supplier, and I think there is room in competition law as it exists to look at, buyer cartels. That's something they're very familiar with. That's sort of, as you very, I think, clearly and eloquently said, Manjushree, that that's the pie that they have adopted. They've sort of said, we are kind of happy to stay here. It can also look at possibly abuse of dominance position. And as Ujjwal pointed out, even in merger analysis, they can look at it. I think where the competition authorities, and this is not just an India-centric problem, this is a problem worldwide, is that we are soft peddling vertical agreements. Vertical agreements are generally considered good. Why? Because they're not protecting, but they are supporting the end consumer. You can suppress the cost as much as you like, provided you get a good price for the end consumer. And I think that's where the biggest difficulty is. That's also the difficulty and I think Jonathan refers to this in his book as well, that, you have the GVCs, the global value chains, the global supply chains. They're usually sort of, these gig workers are integrated into a much bigger entity than they can see in front of them. And I think the competition law soft pedals on vertical agreements, especially in the US. I think vertical agreements have generally been considered harmless, if not, they're very benign. The EU has a huge exemption for all kinds of vertical agreements. They only look at the big ones. And I think because the Indian competition law, as I said in my earlier conversation, is deriving a lot of its thought process, from the Western models, I think it is kind of towing that line as well. And I think that's where a change can be brought in very easily, because the law actually allows, there is very much the option to go after more vertical agreements. I think the only difference is that you don't have a presumption of adverse anti-competitive effect when it comes to vertical agreements. They always have to be established, but perhaps some presumptions can be introduced here to make that kind of relationship more easily, sort of brought within the net. So that's the harm to gig workers that may come from anti-competitive practices. And that's already envisaged in the law. I think there's, as Ujjwal said, there should be a policy decision that we will go after these. We don't. In my understanding of Indian competition law, to the extent that I've studied it, I must admit I haven't paid much attention in 2022 and 23 because I've been doing other things. But I think that has not been the focus. Buyer cartels have not been the focus. Monopsony power or even superior bargaining position or harmful effects to suppliers in vertical agreements have not really been at the forefront, even when the options were there. But what happens when the gig worker is harmed by something that we don't recognize as anti-competitive at present? And that is a more open question. And I think three things that I think are very again, they stand out when we think of Indian farmers versus big agriculture. So I think Indian farmers are a very great source of insight for us when we think about big tech as well. First of all, the superior bargaining position of the platform. I mean, it will always have superior bargaining position, just as, as I think both you and Ujjwal have pointed out, that the disproportionate, supply of gig workers to the very highly concentrated platform economy, the bargaining position will always be very high. There will be, as Vellah said, talked about the economic dependency as well, which is, of course, further entrenched by very one-sided and often standard form contracts. And I think this is something that one of our commentators also, one of our participants rather also pointed out in the chat that, if they don't register with the platform, they can't do anything. And I think that is something that we worried about with the farm laws as well, that, you will have to, these very sort of one-sided contracts, and, you need to be on some sort of a platform to even access these, and that disenfranchises the laborer or the gig worker as well. And of course, finally, then the limited recourse to dispute resolution mechanisms. It's very difficult for the gig worker to access courts. And I think we've seen that in the PepsiCo, the famous sort of sit-in between PepsiCo and the farmers, and it was not resolved in court. It was resolved outside of court, and that was a different kind of pressure. So I think the question then arises is, can we, in India, the Indian Competition Authority can take cognizance of some of these issues without going too far into the social welfare stream, sort of really adopting some economic arguments to include these issues within its framework of analysis, and see what it can do. So the Indian law, as it's presently drafted, of course, is the term enterprise actually includes a person. So I think that is a difference that I think can also be used in favor of the gig workers as well. I mean, the problem with that is that I don't know whether an Albany style exemption would be possible for laborers. So I think that leaves laborers very sort of vulnerable. I don't think anything has been done in that area, but there is a legal vulnerability. There is that loophole. But it also means that gig workers can be recognized as a gig worker market, and harm in that market can be assessed because it is external to the enterprise and not internal to it, as a laborer would be. And I think that because we have the option in India, and of course all countries have this option to broaden the remit of what kind of harm they want to consider. I mean, EU, which we consider as sort of a prime model for all kinds of competition, frameworks, has the internal market imperative. To them, maintaining the internal market is so important that even though that's not a traditional competition goal. It is a goal that EU constantly, well, I mean, it's written in the law, so you can't have a competition case unless you also establish that it appreciably affects trade between member states. So I think there is room for adopting a core principle that is of core importance to an economy. And I think I would think that labor would be of primary interest, because also the Constitution of India itself has that social welfare ethos, which can inform how it interprets its competition law, how it writes its competition law. You have other examples as well. South Africa has used race relations are built into their competition law. So I think that's a bigger job. That's a job for lawmakers, but I think that is something worth considering. And since we like to look at foreign models, I would say there are foreign models. And even if you don't want to change the law, like for instance, in the environmental sort of push that has come in the EU, for instance, that is coming from the EU constitutional documents, which is informing the competition enforcement. Okay, they are not saying we protect the environment at the cost of competition, but they are finding ways to harmonize the two. And I think if the Indian competition law is seen in light of the Indian constitution, I think there is a big space that opens up then for labor to be brought in. And I think that would be, without too much change, that is a way forward. Finally, I think the question you had asked, I just want to say that, you had asked that is it important to train gig workers, or important to raise the awareness of the gig workers? And I say absolutely. And that's not just gig workers, that's everybody should be informed about their rights. But I think that's not enough. I think it's very, very important, but it's not enough, because if the institutional framework is stacked against you, what are you going to do with all this information? I think there has to be a sort of a two-pronged approach, that we do work with the institution. And I mean, this effort is, of course, part of it, right? That we're talking about how the institutions can refocus their energies on the issues that really matter for the Indian economy or for the global South, rather than simply saying that, okay, we're borrowing it from elsewhere and they're doing it like this. And, so yeah, I wanted this to be quick, but I think I haven't been too quick. There you go.
Not at all. I mean, I think it's always a pleasure to hear you, Amber. So thank you for that elaborate explanation. I think we may have a couple of minutes to wrap up a couple of questions. One interesting question that I sort of saw here is an example that someone drew with a moon. This is by Ashish. So, any thoughts on this, Amber or Ujjwal, in that, the idea that we need to restructure our bargainings to more like cooperative models to ensure that structurally we do not allow for bargaining asymmetries? Do you think that's a more tidier approach for India? I mean, again, I'm just thinking about it from institutional design. Do you think that's a more tidier approach, or do we leave this to bodies to sort of take cognizance of this as the digital economy matures? I just want to hear your quick thoughts on this.
Ujjwal, if you want to go first.
Okay, so my thought on this is that I mentioned in that digital public infrastructure approach. And Amma Auto was one of the examples that I cited. And ONDC also, I found that some of the pilot, ONDC is Open Network Digital Commerce, which is again a digital public infrastructure with lots of interoperability. Where also I found that not only consumers, but also the initial finding was that the restaurant people also got better deals. So, but still in the nascent phase. I don't know how it will come up, taking into the market forces into account. But this can be part of a solution, but not the solution, I would say. This can be promoted, and as such, there is now a Ministry of Cooperation in India. So perhaps that ministry also can take up all these issues. And regarding collective bargaining and the unionization of gig workers, I mean, it's not in a very good shape in India. We have asked many delivery boys; they do not know that there exists some, gig unions. And gig unions, we asked how many members you have. They count. I mean, they give lots of count, but from the others, we found that there are many such unions. They one night you wake up and you create a union, and a few people join you, so you have a visiting card and so I think that union is not yet the unionization of gig workers is not yet there. many, particularly in the delivery boys sector. Perhaps in Uber and ride sharing, there is some major kind of union, but not in other gig working sector. So that the exception of EU law provide that the bargaining, collective bargaining is exempted from, is perhaps may not be able to implement this in India if we have. And as such, the Commission of India has been quite laggard or quite kind of went slow on for the MSMEs and all. In fact, recently in 2 cases, MSMEs were found to be cartelizing. It was proved that they were cartels. Still, they were just given cease and desist orders, just because they were recovering from the COVID setback. So that is part of that. But how do we bring those kind of cases? I think the buyer's power approach, I think, in my opinion, would be the best approach in India.
Thanks, Ujjwal. Quick thoughts on
Yeah,
this?
just to, I mean, again, to quickly add, I was doing some research on global value chains in the food sector in India, and Amul stood out as an excellent example of being able to safeguard the rights of the parties as well. So I think they were more able to withstand the pressures that come from global value chains than perhaps other kind of entities. I think that from a competition perspective, the way the competition law is written at the moment, there is no exemption for this kind of behavior. And in fact, if we find that the cooperatives are actually coordinating on prices and dividing markets among themselves, and that could be a serious competition law issue. But as Ujjwal has been saying, I think throughout that it is ultimately, and I think Jonathan, you referred to it as well in your opening statement, that is ultimately a matter of priority setting for the competition authorities, and they have been soft pedaling on local domestic cooperatives, perhaps because they're delivering better results on GVCs. We don't really know how these bargains are struck. It comes back to the political bargain point that we've been talking about. I think for me, there's no sort of, I mean, I'm a great fan of working on buyer power. I work on it all the time. I find it very interesting. So yes, that would be a way forward. But I think that ultimately this has to be a political decision on the part of the government. And from my observation, I mean, I'm not in India. So from the outside, when I observe it, it seems to me that the focus at the moment is, for lack of a better word, is very much on neoliberal reforms. And we are not thinking about social welfare. So I think if that's the current climate, there are benefits to that as well, right? It comes, but there's a short-term cost which the labor pays. And that is really what we're thinking about, the long-term economic benefits that this kind of industrialization will bring, or we're thinking about, the short-term cost price that the labor class will pay. And I think ultimately that's the balance that has to be struck. So no clean answers, unfortunately, but that's where we stand.
Thanks so much for that, Amber. I think, unfortunately, we're running a little short on time, and this is a conversation that I'm hopeful that we will continue in some shape or form, either through future discussions or some other sort of collaboration. But thank you again, everyone, for your time today, especially Jonathan. And I cannot imagine what's waking up at 6:45 in the US right now must be like on a cold winter morning. So thank you so much for taking your time out, probably out of your sleep schedule, and making it to this webinar. Thanks again. Thanks a ton. Thank you, Vellah. Thank you, Amber. And thank you so much, Ujjwal, for joining. And again, thanks to my wonderful colleague, Anuradha, who helped me put this together, and the GIZ team, Miriam and Sarah, who've been very helpful in coordinating and putting this all together. And I look forward to more engagement on the GIZ gig economy course. Thanks, everyone.
Thank you. Thank you.
Thank you. Thank you.
Thank you very much.
Thank you.
Thank you, everyone.
Thank you. Bye.
Thank you.